Does my spouse automatically get what I have when I die? Hi, I'm Georgia estate plan attorney Sharline S, and I've helped many Georgia families prepare for their futures, and I wanted to do this video to answer this frequently asked question. Does my spouse automatically get what I have when I die? Your spouse will not automatically get what you have when you die unless your assets are titled or owned in a way such that ownership automatically transfers to your spouse upon your death by operation of law, or the assets become the property of your spouse through beneficiary designation. For example, if real property is owned with your spouse as joint tenants with rights of survivorship, then if you die before your spouse, the property will transfer in its entirety to your spouse by operation of law. The same is true if you have jointly held bank accounts. The account will transfer to the surviving joint account owner. For assets individually held in your name, in order for these assets to transfer automatically when you die, you will need to designate your spouse as the beneficiary of the assets upon your death. If you fail to name your spouse as beneficiary of the assets, or the assets don't provide for beneficiary designation, then your assets will be distributed pursuant to the instructions left in your will or trust, where it will be important to state your wish for your spouse to get what you have. If you don't have a will or trust, then your spouse will receive all of your estate only if you do not have any children. If you have children, your estate will be divided between your spouse and your children, with your spouse getting at least a third of your estate. If you have additional questions about what your spouse is entitled to when you die, please do not hesitate to reach out to me and I will help you in any way that I can. Thank you for watching.